Record in the matter 05 FA 78 in re the support or maintenance of NSR. Appearances are, we do have Mr. Reynolds appearing in person in custody with his counsel Philomena Quebec in person. We have corporation. You're not on his child support?
I'm not on the child support. I'm not on this one.
Excellent. All right, then strike that. She's on his other matters. So he's appearing pro se. We have Corporation Counsel Stephanie Thomas Schmidt in person. We're set today in this matter for a motion hearing. I am just going to have to ask the baby step outside. We were here on November 21st, 2025, in which Mr. Reynolds failed to come to court. Ms. Stephanie Thomas Schmidt.
Right from the start, you can feel the tension in this courtroom. This isn't just about missed child support payments anymore. The judge is looking at a long pattern of avoiding responsibility.
Corporation Counsel, what is it that you're asking for today's purposes?
Your Honor, I'm asking that the stay be lifted on the entire jail sentence and that Mr. Reynolds be confined for 35 days consecutive to any other matter. I would note he does have the pending criminal matters and the criminal cash bond that'll be addressed separately. I do believe this is appropriate. This contempt action has been going on for at least 2 years. Mr. Reynolds' non-appearance on November 21st is particularly egregious given he had a missed appearance on November 5th, was given a warrant, was able to pay that warrant given the 21st date. He was out of custody for approximately a week. And during that week, he missed court here, missed court in his criminal case.
Notice what the prosecution is pointing out here. The only time payments came in was after warrants, bail, or jail pressure. That's a major problem because courts want voluntary compliance, not forced compliance.
And was given the $3,000 cash warrant that we're here on for child support. He has not made payments since he was, we have a tax intercept, it looks like. No, that was the cash bond, I apologize. Posted in November, that came through in December. And we have $14.21 that came through in January. We've had nothing since then. Mr. Reynolds is under an order. It's a weekly order that amounts to $512.24 most months, $92.32 owed on arrears each month. That has not been paid. Mr. Reynolds' arrearage total is $24,214.07 plus $554.04 in costs and fees. Back in October, when we filed for the motion to lift the stay, we were requesting only 15 days. The stay be lifted on only 15 days, but given the conduct since the filing of that motion.
Now the emotional side of the case starts coming out. Reynolds talks about losing his aunt, losing motivation, and basically spiraling after things fell apart. These moments remind you that courtroom cases are rarely just black and white.
I do believe it appropriate to have the full 35 days, the stay lifted on the full 35 days.
All right, thank you. Mr. Reynolds, you're here without an attorney, and you can retain an attorney if you wish to do so. What's going on?
That court date I missed, I just think misinterpreted what was said because when I posted the bail, I misinterpreted that I would have to that would be taken for the thing, and I wouldn't have to come to the court date. I would just have to contact the office, but I didn't do that either. And so the warrant was for me, and so I was just all went downhill, and then I just went on a run until just recently. And I lost my job, and like just a lot of stuff happened where I like I didn't really care anymore. But like my aunt passed away, and that's like suddenly, I don't know if she was bad cancer, and then she passed away during that time. So I just really didn't really care much. But like and I know that's selfish of me, like to just put everything on back hold. But like I do take care of my children and stuff. I just want you guys to know that like it makes it seem like I don't, because you guys want all this money from me, which I don't have. Like it's an insane amount of money you guys ask for me. Like I don't have that much money.
Have you looked at any options of filing any motions if you're unemployed or you have no money?
No, I had a warrant, so I just like didn't really try to do nothing. But I do have employment waiting for me now. Like, and that's not a cash job like my last job was. Before I told you it was hard because it was mostly cash. But this job is it's a maintenance job through the same place in Hurdle.
The judge immediately locks onto one important detail: a job with official payroll records. In child support cases, cash jobs make it incredibly difficult for the court to track income and enforce payments.
It's all paper, so it'll be paid bi-weekly. They're just waiting for me to get out and go get the paperwork and start that.
How much an hour?
I believe it's between being a tribal member and then being I think it was between 15 and 17 an hour. And then with that, I can easily that you guys will get your payments on time, because it'd be all through the payroll department. I won't have that's not a cash tip job. That was my biggest thing, because I want to get checked, or like check stubs even from my last job, because I made the cash tips, and I would just give my kids the money from me to them without.
You knew you can't do that.
Yeah, I know. Like,
I mean, you can in addition to your child support,
Yeah.
but you have to pay your child support. And
I know.
it hasn't been asked to be looked at or modified or anything like that through a motion. So what it is what it is.
Yeah, I know. I was just able to say I'm sorry for that, and then this job will, because they offered me the slot job too, and I told them I'd rather take the maintenance job because of that. It would be all paper.
And I will let you know that on November 17th, 2025, when we had the hearing, the court amended the warrant to $2,000 cash, which you were able to post, and and this is the minutes. I mean, you know how to use CCAP, right?
Yeah.
Because you go on it and you look all the time, right? To see if you have a warrant?
Once in a while, yeah.
Yeah, and so you know how to look up your cases, right?
Wow. The judge is clearly not buying confusion excuse anymore. That "I can tell your BS" comment completely changes the tone of the hearing. At this point, credibility is becoming a serious issue.
Kind of. If I can,
Don't tell me kind of.
I just type my name
I
in.
know I can tell your BS.
Okay.
Don't tell me kind of.
All right. Well, yeah. Then.
You do, right?
Yes.
And so when I look at the minutes from that hearing, and I'm quoting all of this, as to 05 FA 78, the court will amend warrant to 2,000 cash and sets another status conference for this week to determine if the stay will be lifted or the purge will be extended. Child Support Agency, CSA, may reschedule.
See, that's
They may reschedule.
okay.
That's where it was, could it be a different date? Otherwise, it's that date.
Okay. That's where I didn't interpret. I'm sorry about that.
Because you understood you needed to go talk to child support, correct?
Yeah.
And you didn't do that?
No.
How many days credit does he have as of right now?
He's been in custody since the 27th.
24th.
The 24th?
Yep.
Of April?
Yes. Our paperwork. Okay, I see it. $12 days credit.
12 days. All right. And do you understand what child support is asking, Mr. Reynolds, to lift the stay and have you sit 35 days? Because
Yes.
When the judge says enough's enough, That's basically courtroom language for the patience is gone. 2 years of miscompliance pushed this case to the edge.
Enough's enough. It's been 2 years that you're given this purge agreement,
I know,
and you haven't complied with it at all, not in 2 years.
I know.
And the only way that money has been received is when
It's
you
to my bail.
are facing jail time,
Right,
or you miss court and a warrant is issued, right?
right.
So, do you have any reason why the court should not find that you should be sanctioned to 35 days?
No, I don't. Like, I honestly, like, I probably deserve that. But like, if I get that, then I might miss out on this
You're
job.
not going to miss out on the job. You and I both know that.
This job, it's like, I might have another job.
Mr. Reynolds, you and I both know you're not going to miss out on that job. Even if you sit 60 days, you'll
Okay.
still have the ability to go reapply, right?
For other jobs. I'm just saying this specific job.
Well, I'm not so sure that you won't have the ability to do this specific job
Okay.
later. So based on that and the fact that there's no real argument here, the court is going to lift the stay 35 days of jail.
Here's the interesting part, though. Even after sentencing Reynolds to 35 days, the judge still gives him a fresh start financially. The old purge agreement is wiped away, meaning he gets one final chance to rebuild from zero.
Consecutive to any other sentence. And then with that, that means that the purge should be done and he starts all brand new, like a brand new baby.
Okay.
Okay?
Yep.
So it all starts new.
Okay.
And with the amount of the arrears and the, issues with compliance on the purge, if you go 120 days without paying, we can refer it for felony criminal charges.
Yeah. I understand
You
that.
don't want that.
No.
But here's the thing. Child support isn't going to start and make you collect while you're in custody. It's going to start the month after,
Okay.
or probably the month of, I don't know when he would be released. But you'll have time when you're released to go look to see if you can keep that job or other similar job
Okay.
within the organization.
Yeah.
So 35 days and the purge starts. So
The
purge
purge will
is
be
gone.
completed.
Agreement, that order's gone. You
Okay.
start brand new. So you're going to start fresh with your monthly payment and your arrears payment, and then you're going to consistently pay, because as you heard Ms. Thomas Schmidt, they may not give you an option to have a purge
I know.
next time.
Thank you for that.
Okay. So we are adjourned as to that matter.
So do I get them days credited?
Oh, yes.
Okay.
35 days plus 12 days of jail credit. All right, we're adjourned on the family matter. Ms.
That's
Kevick,
consecutive.
consecutive, yes. Ms. Kevick,
Thank you.
we will call cases 24 CT 08, 25 CM 241, State of Wisconsin versus Brett Reynolds. The state appears through District Attorney Kevin Schmidt in person. Mr. Reynolds appears in person in custody with his counsel Philomena Kebick in person. We're set today for status conferences. He missed court. He had a warrant, $5,000 bail to bail him out cash. Ms. Kebick, you are brand new on this case, but I don't know how new, or if you've had the ability to talk to the district attorney or to do anything on the matter, but you want to update the court?
Yes, absolutely, Your Honor. So I was appointed Tuesday. I was appointed, I think, maybe late in the afternoon on Monday. I received the complaint, reviewed the complaint, had some difficulties in connecting with my client yesterday. We were able to meet in person at the jail today, go over the complaint, the elements, and address his constitutional rights.
Now the case shifts into criminal court territory, and the vibe changes immediately. Family court focuses on payments and responsibility. Criminal court focuses on charges, constitutional rights, and legal strategy.
Would I will be filing a Four Corners motion within 10 days. And then I have a discovery demand that I'll be presenting to the district attorney's office for both of the cases.
Okay, so you went over that. He understands the charges and maximum penalties.
We actually didn't go through the range of penalties, so I didn't do that.
All right, so the penalty for 25 CM 241, that is what we're on for an initial appearance. It's obstructing an officer. It alleges on or around December 3rd, 2025 in Burnett County, Wisconsin, you knowingly obstructed an officer while such officer is doing an act in an official capacity and with lawful authority. That is a Class A misdemeanor. Upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months or both. Do you understand that count and that maximum penalty, Mr. Reynolds?
Yes, I do, Your Honor.
Does he require a formal reading of the entire complaint, or do you waive that, Ms. Kevitt?
We waive that.
All right. Not guilty plea will be entered on your behalf as it relates to this charge. The court will grant you the ability, if you need an extension of 10 days, you can just ask right now. Or whatever you feel comfortable.
We'd like to get this in.
All right. So the court will, not guilty plea, you can file your motion. He does have 24 CT 08, which is hanging out there. And I'm going to tell you, it is a really old case, and I'm setting that for trial right away unless the matter's resolved and there's a global agreement, because it's 593 days old.
It's very old.
I would rather get that taken care of.
What, Mr. Reynolds?
I would rather get that taken care of.
I would rather you too. I want you to get your license. That's what we've been waiting for.
Yeah.
I was in the process of that, but then I got a letter from the DMV saying they took it away indefinitely. So I don't know what that means, or if I can even get that back now, or.
That is something that Ms. Kebick should be privy to. You should refer that information.
I did today when I met her.
Otherwise, the offer for that case, if you're unaware, Ms. Kebick, it was get the license and have that matter dismissed, or plead to the charge operating while revoked for costs.
Yeah, and I'm fine with just pleading that out.
But you talk to her, okay?
Okay.
Talk to your attorney.
Okay. If I can get a chance to talk to the district attorney, we'll go through that.
Yes. There could
that
be a
sounds good.
possibility for a global offer. Obviously, you have to wait to see about getting your discovery and where you want to go there, and whatever with the Four Corners motion. What I'm going to do, Ms. Kebick, you do all the things that you need to do, but I'm going to give you time. I'm going to set this for something like 45 days down the road.
Okay.
Because that gives you time to hopefully get all the discovery, get all the things, and do some negotiating.
Yep.
You're more than welcome to come here in person for the next hearing, but you are coming from a distance. So I'm okay if you want to appear by video conferencing, if that's okay with Mr. Reynolds. And he's nodding his head up and down, yes, so that would be fine. Ms. Kebick, even if this matter is something that can resolve through a plea and or sentencing, you may still appear by video conferencing. I'm okay with that. Again, as long as Mr. Reynolds is okay with that. Save you time, save some money for the state.
I appreciate that, Your Honor.
Let's get a date.
And we'd also like to address bail.
Yes, we can do that. And this is your case, Mr. Schmidt,
The OAR is
but the other matter is not.
correct. This was before we changed that.
A global offer is basically a legal package deal. Prosecutors try to resolve multiple cases at once instead of dragging everything through separate trials. It saves time for everyone involved.
You'd be able to make a global, or how are you going to handle that in your offer?
The global offer is if he pleads to OAR, we'd read in the obstruction.
Leads to OAR, read in the obstruction. But do you want 45 days or do you want a little less?
45 days would be great.
I can give you June 19th at 10:15. And Ms. Kebick, right now I'm just gonna set it for a status. However, I'm gonna let you know that if you reach an agreement and you want to do a plea and sentencing, and again, you want to appear by video, as long as you give me a week's notice, we'll be able to convert it and just make sure I won't double book, triple book, or do anything in that time slot, and we can do a plea and sentencing.
Okay, so June 19th at 10:15 a.m.
10:15 a.m.
Okay, that works for me.
All right, thank you. As to bail, you may proceed.
Okay, so Your Honor, I did have a chance to confer with my client, and he discussed some challenges in remembering and understanding the importance of the hearings and the court dates. He and I are now in touch. I have his phone number, his mother's phone number, and we're going to, we have a pact. We're going to talk about the court dates and make sure that he's going to appear. He did address the court relative to his employment goal. He wants to get employed and up to date on his child support. The really great thing about this job that he's been offered is that he can walk there. It's close to his home. And again, he's going to be paid through a paycheck. So he's really striving to get current on his child support and move forward. And that's one of his biggest goals. And so the bail right now is set too high for him to be able to post bail. So he's requesting a reduction to $750, $1,000, so that he's able to get out and get back on track with both his child support and then getting back with his driver's license status.
Mr. Schmidt?
I don't object.
Here's the deal. He's going to be sitting for a little bit,
Yeah.
and you've heard the offer. He does owe, we have another case or two on for past due fines and fees. That's only $130.07. I want that taken care of as soon as you practically can take care of that. I don't want to have to issue a warrant and drag you in. That wastes way more resources and time and money on the county to do that. Okay?
I can probably take care of that 130.
Oh,
today.
actually, I guess it's with interest and all of that, it is $216
I might be able to take that
and
care of that
6
today.
cents. Okay, I want that taken care of. Okay, I don't want to have to hound you, and I want you to pay your child support. I don't want to have to hound you.
I know.
He's been sentenced now to 35 days with child support. I'm fine. It's consecutive, so it doesn't matter.
This might be the most important observation from the judge all day. Reynolds isn't considered dangerous. He just keeps failing to show up in court. And honestly, that distinction probably helped him avoid a much harsher bond.
If I put on cash or signature bond or whatever in this case, I'll amend this to a signature bond, Mr. Reynolds. And she hit it on the head. He has an issue with appearing for court. Not like he's a terribly awful, violent man or anything of that nature. He just has a problem coming to court. Okay? So, but I do want to take care of that $216.06.
I could probably do that today, actually.
Please do that today. We'll get those two cases off. Signature bond on the other matter. You'll be released after you've sat the total 35 days. We'll be back here and we'll figure out what's going on in the other cases. Okay?
Thank you.
Get your license information to Ms. Kebick.
Do we even have a bond in the criminal cases?
Well, I think we just had a warrant, so yeah, maybe we do need to do bond. Signature bond. No driving without a valid driver's license. I'm gainful employment.
Okay.
How much do you want the signature to come on?
500. All right,
Okay, thank you, Your Honor.
thank you.
Thank you.
We are adjourned.
Thank you.
All right, be in touch.
Okay, thanks.
Not gonna call the two other cases that they would
I just put a note on in the minutes that he needs to pay those.
Pleasure to meet you, Ms. Kevitt.
Oh, really nice to meet you. Thank you so much. Nice to meet you.
Next matter.
13 FA 95 in re the support of KM or KLM with Kyle Lewis.
We will go on the record in the matter 13 FA 95, State of Wisconsin versus, and not State of Wisconsin, in re the support of and maintenance of KLM. Appearances are, we do have Kyle Lewis appearing in person without counsel, Corporation Counsel through Stephanie Thomas Schmidt. We're set today for a motion hearing. We were last here on March 11th, 2026, in which we had some good progress, I thought, and Mr. Lewis was working or going to work. Ms. Thomas Schmidt, where are we here today? Why are we here?
Well, we've had kind of a mixed bag over the past couple months. Mr. Lewis, we received some taxes in February. He was to pay, or in March, I mean, he was to pay $250 before March 31st. We received that payment, though it posted in April. He was also to pay $423.40 before the end of April. We did not receive that payment. That was to catch him up from what he was behind on the purge. So he was also to continue making his regular payments of $95.03 per week, with $6.92 per week to arrears. We have not received that payment. So he was to keep in contact. He has done a decent job of keeping in contact. He reported that he had been working, fell off a roof and had an ankle injury, wasn't working for a couple weeks, went back to work, possibly re-injured the ankle, back to work, and is now working for a contractor in Grantsburg. But he was to do work searches for the weeks that he wasn't working, and we didn't receive any work searches. He has a 45-day sentence with 8 days of credit.
Now compare the second case with Kyle Lewis. Unlike Reynolds, Lewis stayed in communication with child support services. Even when payments fall behind, courts usually respond better when someone keeps communicating.
When I was preparing for this hearing yesterday, I was very torn as to what I should request, and I don't want Mr. Lewis to lose the job with the contractor in Grantsburg, but we need payments. We need regular payments, and that has been a struggle. I guess my request, and I should have checked with the jail before making this request, is that we extend the purge. Instead of 2 lump sum payments to catch him up, Mr. Lewis's payment on arrears increase from $6.92 per week to, well, we leave the arrears payment as it is, and he pays an extra $50 a month. And that we have a review in 2 months. Mr. Lewis will come back to court if we're not fully satisfied as to his compliance, that money is coming in, that he continues the good contact that he's been having, and that he arranged with the jail that the stay be lifted on 2 days of jail to be served before the next court hearing at a time arranged with the jail. And that would be July 8th is the date that we'd be requesting. I think the 2 days jail is something that could potentially not interfere with work. Gives him 2 months to arrange it so it doesn't interfere with work, but also sends the message that you have to stay on top of this. You have to comply. You've been given a multitude of chances. We've tried to work with you a multitude of ways, and you're getting to the end of the line.
Mr. Lewis, do you understand all that Ms. Thomas Schmidt is asking and stating?
Yes, I do, Your Honor.
What do you want to say?
I got $300 today and going back to work, and I can bring more money on Friday. I had contact child support, asked how far I was behind. There was a misunderstanding between us. She told me $160, and she thought I meant for the month. I thought she meant to not even have to be here today. And like I said, I started with a new contractor. He's going to help me get my LLC, and I'd be carrying my own insurance and making the steps I've been working on. And yeah, I have $300 today.
What brings him current on the purge?
Since last time we were in court, not since the beginning of the purge, but since his court date back in March, he is $991.95 short on the purge.
That's a lot behind.
Yeah, I know. I like literally the day after I had court here is when I fell off. I fell off a ladder 10 feet up and rolled my ankle. I was out for 2 weeks, got a boot from a friend and worked with it as much as I could. But yeah.
I guess for context, Judge, the total arrearages are $6,712.82. So significant, but maybe not the most significant that we've seen.
Yeah, it's not the most.
And I'm not relying on them, but my federal tax income is like $5,000 for 2005. But I got a letter from the IRS.
2025.
Yeah. It's $5,000. But I got a letter from the IRS yesterday saying that they're reviewing it. And then I also have to backfile my 24. I was waiting for a W-2 from a person I thought I worked for in 24, but it didn't. So now I can backfile my 24 taxes as well. So that's another lump sum, and I should have everything all caught up.
Well, if that's the case, if that is actually the case, then it'd be intercepted.
It would be, yes.
Yeah. Yeah.
But if it's under review, that could take a long time.
I know. And I think that's what happened with my 2024 taxes. Something got messed up in the numbers when I had help filing them.
Here's what I'm going to do, Mr. Lewis. I want you to work. Ms. Thomas Schmidt wants you to work.
And with that,
Quay wants you to work. The child wants you to work. Everybody wants you to work. Here's what I'm going to do. Because you are in contempt, and I don't know when you let child support know about your injury and not being able to meet your purge. But either way, you haven't met your purge. I'm going to order $300 to be paid here today. And then I am going to order that $700. I'm going to order 2 days of jail prior to July 8th. Okay, 2 days of jail.
so come in on a Friday, leave on a Monday morning.
Well, actually, with the law, you probably wouldn't have to sit only one overnight, or maybe 2 overnights. I can say 48 hours.
This is classic courtroom pressure. The judge orders 48 hours in jail, but also gives Lewis a clear way to avoid it. Pay the money, stay current, and the jail time disappears. The goal here isn't punishment alone, it's compliance.
I'm going to say 48 hours of jail, not 2 days, 48 hours of jail. But if you pay the $700 to catch yourself up on that purge, and you pay it by And that means he still has to make his monthly payments as well.
Correct.
But if you pay an additional $700 by June 25th, then I'll vacate that 2 days, that 48 hours.
Okay.
Okay,
And that's $700 on top of the 300 and on top of his monthly.
correct. So you have to pay the $300 today.
Yep.
You have to pay $700 by June 25th to purge those two, or to have the court vacate those 2 day or 48 hours that the court ordered, plus continue to make your monthly payments.
Yep.
And arrears payment.
Yep.
Okay, you understand that?
Yep.
Sound good?
Sounds good.
All right, so we'll set the next hearing for July 8th. So you're going to have to, if you can't pay that $700 by the 25th, you have to sit those 2 days before the next.
Before the 8th, otherwise it'd be 45 days or whatever.
Correct.
Okay.
You understand?
Yep.
Okay.
Thank you very much, Your Honor.
Anything else, Ms. Thomas Schmidt?
No, July 8th at 10:30.
Correct. All right, thank you. We'll see you then. You can come get your notice.
Stop by the window and make your payment before
Do you have Mr. Erickson?
We do have Mr. Erickson.